The Freedom of Information Act requires federal agencies to turn over information or documents when someone submits a request under the statute. We call this a FOIA request. And there are 9 important exemptions or exceptions to this where the agency doesn't have to disclose the information that's been requested. The longest of those, in terms of details and subsections, is Exemption 7, which relates to information that's compiled for law enforcement purposes. And that's what I'm going to talk about here. I'm Drew Stevenson. This is for my administrative law course. Let's dive in. So Exemption 7 to the Freedom of Information Act begins by saying that it exempts from disclosure under FOIA records or information compiled for law enforcement purposes, but only to the extent that the production of such law enforcement records or information, and then it has a few subsections. So A is that the information could reasonably be expected to interfere with law enforcement proceedings. Notice that even though most FOIA exemptions are categorical, the privacy exemptions under 7A require a balancing between public access and confidentiality of the agency. Section B of Exemption 7 says that it exempts from disclosure under FOIA records that would deprive a person of the right to a fair trial or impartial adjudication. So that's subsection B. We then come to FOIA Exemption 7C, or subsection C, that applies to information that, quote, could reasonably be expected to constitute an unwarranted invasion of personal privacy of some individual. FOIA Exemption 7D exempts from disclosure records that could reasonably be expected to reveal the identity of a confidential source or informant and any information that's been furnished by a confidential source. Exemption 7E under FOIA applies to information or records that have been compiled for law enforcement purposes that would, quote, disclose techniques or procedure for law enforcement investigations or prosecutions, or would disclose guidelines for law enforcement investigations or prosecutions if such disclosure would reasonably be expected to risk circumvention of the law. In other words, if we tell you exactly how the police do their forensic analysis in the CSI lab or something like that, it might enable criminals who are carefully planning ahead to somehow work around that or outsmart law enforcement because they know the practices and procedures and techniques that law enforcement follows, and they're trying to evade detection for their criminal activities. Next, we come to Exemption 7F, and this applies to records or information, if they were compiled for law enforcement purposes, that could reasonably be expected to endanger the life or physical safety of any individual, let's say retaliation or trying to silence potential witnesses and so forth. Keep in mind that Exemption 7 applies only if records were compiled for law enforcement purposes and meet one of the 6 enumerated harm types in sections or subsections A through F. On the other hand, note that, or keep in mind, that records that were not originally compiled for law enforcement purposes might be able to still meet this threshold later if they are what we call recompiled for law enforcement purposes. We call these recompilations of records. In terms of what happens when you get into court under Exemption 7, all circuits, all of the federal circuit courts will look at the nature of the responding agency. By responding agency, we mean the agency that received a FOIA request and is saying, we don't want to turn those records over and we're invoking Exemption 7. But the circuits are actually split about the significance of which agency is involved. So some circuits actually demand a rational nexus between law enforcement and the records, even for an agency that usually just does law enforcement, like that's its primary purpose, like the FBI. So in those circuits, even the FBI, which is by its nature a law enforcement agency, would have to show that the records that are being requested have a rational nexus to criminal investigation. On the other hand, there are other circuits that will grant a per se determination that the threshold for Exemption 7 is always met if the agency is primarily a law enforcement agency like the FBI. And not all agencies are, obviously. There are agencies like OSHA and the EPA and the Department of Education that have mixed functions. They promulgate regulations and rules and issue permits and licenses and accreditations and so forth, but they also do some enforcement actions. And so those agencies have to have an individualized determination in basically every circuit if they're going to invoke Exemption 7. But in some circuits, the agencies that all they do is law enforcement, like the FBI, they wouldn't have to do that. That brings us to the end of our quick overview of FOIA Exemption 7. Thanks for watching.